The first hearing that you would have in front of a judge is called an initial hearing, and that's just a general rights advisement, and many times you don't even have an attorney at that point. That's where issues of bond and release are discussed, and you're informed of the charge and the penalties for the charge that you're facing. You're then given a next court date, which in most instances is a pretrial. A pretrial is a general administrative hearing. It allows the two attorneys, your attorney and the state's attorney or prosecutor, to meet and discuss the case, to exchange information, and to inform the judge of the progress that's being made and whether they need additional hearings or a trial. Those are generally very informal hearings. Some courts don't even require defendants to be present. They allow attorneys to do it among themselves. If you are required to be present at a pretrial, don't expect much more than a very brief encounter with the judge sitting next to your attorney and hearing an explanation of how things are going and whether the process is moving along and what the next step the court needs to take is from the attorneys. The next type of hearing is some type of evidentiary hearing. That can be a suppression hearing, that can be a probable cause hearing to review the arrest. There are numerous evidentiary hearings. That's a setting that will be much more lengthy. It will generally be just you and your attorney and the state and their attorney and their officer. Whereas pretrials, you may have 30 or 40 scheduled on one day and each person takes a minute or two in front of the judge. An evidentiary hearing could take a couple of hours and it's just that case that day. Usually evidence is admitted, witnesses are sworn, testimony is taken, lawyers make arguments. And you should definitely have met with your attorney before showing up for an evidentiary hearing, as opposed to a pretrial, which may not require you to meet with your attorney first. Finally, there are trials, bench and jury trials, and that's simply where the entire matter is resolved if you haven't reached a plea agreement. And of course, you would have to be present there, and it would be a lengthy process. Bench trials would be an hour or two, and jury trials can range from a day to weeks long. When you're getting ready to show up in a courtroom for the first time, go in with some basic information. Call the court beforehand and confirm your date and time. If you have an attorney, call your attorney's office and confirm your date and time. That's the source of the biggest confusion among courts and people who are in courts. Times get wrong. They're entered wrong in the computer. They're written down wrong on records. And the problem is the court doesn't get penalized for you having the wrong date and time. You do. If you fail to appear for a court appearance, a judge may issue a warrant to have you called back or revoke your bond. If it happens chronically, that's very likely to happen. If it's a one-time deal, it's not as likely. But needless to say, call beforehand, either your attorney or the court, and confirm dates and times. Once you arrive at court, most courts want you to check in. Some courts have a separate office and not the courtroom. So if you walk up to the courtroom and the door's locked, look for the office. There will always be a secretary available. Tell them who you are, why you're there, and let them check you in. That way they know you're there. And they can get to you more quickly when they start calling cases. Then go in. If the courtroom's open, walk straight in. There will be a bailiff or some clerk at the bench. The judge may not be on the bench. Walk up, introduce yourself, and tell them who you are and why you're there. That means you're checked in. Then have a seat. You're either waiting for your attorney or you don't have an attorney yet and you're waiting for the judge to take a bench and address them. When the judge calls your case, if your attorney's there, walk up, sit next to your attorney, and let him do most of the talking. If you don't have an attorney yet, walk up, have a seat at your table. There's a table for the defendants and a table for the state, and explain to the judge why you don't have an attorney yet and whether it's because you simply want to represent yourself or because you haven't had time or you don't have the money yet to hire an attorney. And let the judge deal with that as his court deals. All courts have processes for dealing with how to get people attorneys who need attorneys. But you have to tell them you need the attorney. When you arrive in court, you should be presentable. Pre-trials we've talked about, you don't have to be dressed up fancy, but you should definitely look nice and present well. The judge is going to start getting an impression of you when you appear in front of him. So's the prosecutor. The prosecutor is the one who's going to make an offer to you. And if you make a good impression and begin to convince them that you don't belong there, you're going to benefit from that impression. So always look good and conduct yourself well. Be as cooperative with the folks in the courtroom as you were with the police officer. Don't be intimidated. Your rights are extended there. Judges know that people who aren't in courtrooms a lot may be a little nervous, but don't be intimidated. They're not there to hurt you. They're there to help you.